Honourable members of the Justice Committee, I appreciate the chance to discuss how our legal system supports defendants in criminal trials through special measures. Such measures are designed to aid those who are vulnerable and intimidated, ensuring they can present evidence effectively and mitigate undue stress. Our examination today is framed by the overarching principles of a fair trial and the capacity to participate meaningfully in one's defense. However, the current provision for defendants are lacking, often disproportionately benefiting witnesses. Given our justice system is founded on the presumption of innocence, we cannot overlook these imbalances. Today, I'll first scrutinize the constraints of the life links within special measures that may undermine the principle of effective participation, and second, evaluate how the anticipated intermediaries provision could lead to an imbalance, compromising the equality of arms. I will conclude with proposed reforms to address these critical areas. Firstly, life links. Under the Youth Justice and Criminal Act 1999, conflict with the principle of effective participation. Courts authorize life links if it is in the best interest of justice. For those under 18, the suitability of life links depends on their intellectual or social ability to participate in courts. Adults over 18 need to meet specific criteria like having a mental disorder or significant impairments affecting their courtroom ability according to Act. However, Bottoms and McLean noted that the eligibility requirements for special measures like life links are stricter for defendants than witnesses. Witnesses under 18 automatically qualify, unlike defendants, a disparity criticized by the Royal College of Psychiatrists as anomalous and unacceptable. Courts additionally consider factors like age, socioeconomic background for anxious or fearful witnesses, but not for the defendants, creating a higher barrier for defendants to access special measures and focusing solely on their capacity to participate, neglecting the quality of evidence compared to the broader criteria for witnesses. Defendants are entitled to a fair trial, but barriers associated with life links could lead to ineffective participation. Hall contended that defendants who are compelled to appear in court due to violating the law should not be eligible for special measures. However, this overlooks the fundamental differences between passively observing and actively participating in a trial. Special measures like life links aid defendants who are physically present but struggle to engage due to vulnerabilities. For instance, defendants with a HAD might manage to attend a trial but find it extremely challenging to actively participate and provide coherent evidence, illustrated by Fargo. This distinction is crucial since the quality and consistency of evidence under stress can significantly affect jury perception, potentially compromising the fairness of trial. According to Article 6 of ECHR, which ensures the right to a fair trial, vulnerable defendants should be allowed full participation with special measures to ensure their evidence is coherent and effectively communicated, therefore supporting their ability to be heard equally in the trial process. In proposing suitable reforms, Faircloth's reports on unfitness to plead highlighted the Law Commission's recommendation for mandatory screening of defendants under 14 for participation difficulties. This suggests an alignment of life links provision for defendants with those available to witnesses. These reforms would make life links more accessible to all vulnerable parties and increase awareness of this option. Additionally, Talbot advocated for clearer interpretation of the Criminal Practice Direction and to better utilize life links. For example, HAD defendants might struggle to recognize authority figures like judge without wigs, illustrating the challenges faced. Pre-trial court visits are ineffective as to familiarizing themselves as the actual trial settings differs significantly, which underscores the need for broader protection for vulnerable defendants to ensure they receive adequate support during trials. Secondly, the existing intermediary system disproportionately benefits witnesses over defendants, impacting the equality of arms. Section 33BA notes a prospective yet unimplemented law will allow defendants to use intermediaries, marking a significant improvement. However, the Criminal Practice Direction 2023 specifies that while courts can use intermediaries to assist defendants, their appointment is not obligatory. Even they could improve the trial process. Intermediaries are particularly considered for defendants under 18 or those with severe communication difficulties that legal representatives cannot adequately address. Despite this lack of intermediaries is not seen as inherently unfair, as the direction suggests using ground rule hearing in pre-trial management to facilitate defendants' participation effectively, which demonstrate judicial discretion aimed at balancing trial fairness with procedural flexibility. However, case law on the use of intermediaries for defendants reveal a varied approach. While Russian decisions restrict their use to exceptional circumstances, whereas R.M. Bromley Youth Court case broadened their accessibilities for young defendants. However, the lack of secondary legislation creates uncertainty regarding their full applicability. Appointing an intermediary for the entire trial duration remains exceedingly rare. Crucially, while defendants have the right to be fit to plead, the charges associated with using intermediaries can compromise the equality of arms principle. The absence of special measures might lead vulnerable defendants to avoid testifying or plead guilty, affecting trial accuracy and fairness. Their reluctance to participate could also result in negative inferences from silence, underscoring a significant justice gap. Furthermore, the Law Commission criticized the current fitness to plead criteria as overly narrow or too stringent. The Advocacy Training Council notes that the effectively managing vulnerable individuals in court requires specialized skills, yet there's substantial ambiguity over the availability and provisions of intermediary, highlighting a systematic lack of support for vulnerable defendants in the judicial system. In advocating for reforms, Talbot proposed implementing statutory provisions not only for the use of intermediaries for defendants, but also creating a unified register of intermediaries covering all vulnerable parties, including witnesses, victims, and defendants, within the criminal justice system. Currently, while witnesses have access to registered intermediaries via the scheme, the Ministry of Justice Witness Intermediary Scheme, which mandates training and adherence to ethical standards, while on the other hand, defendants only rely on non-registered intermediaries without any formal recruitment, training, or accreditation. This creates a disparity in the quality of support provided, with defendants receiving services that lack national standards or even quality assurance. Talbot recommends that all intermediaries irrespective of their role should be registered and subject to stringent recruitment and ongoing professional standards to ensure consistent and equitable treatments across the criminal justice system. In conclusion, the current provision for special measures in criminal justice system requires significant reform to uphold the foundational principles of fairness and equality. The inconsistent application of life links and the limited use of intermediaries for defendants undermine effective participation and worsen the equality of arms, leading to a systematic bias favoring witnesses. This imbalance threatens both the integrity and outcomes of the trial process. Legislative and procedural reforms are essential, including expanding the use of live links for all defendants and establishing a unified register for intermediaries as advocated by Talbot. Such reforms will ensure equitable support for all parties, maintaining consistent standards for training and ethics. Implementing these changes is not only a legal imperative, but also a moral duty to guarantee that every participant is given a fair opportunity.